Welcome to This Explainer. Okay, let's just jump right in. If you've been living in the UK for many years, there's a major tax change you absolutely should know about. Starting in April 2025, the UK officially introduced a residence-based system for inheritance tax. And what that means is, long-term UK residents may now become subject to UK inheritance tax on their worldwide assets, depending entirely on their circumstances. It is a complete game-changer for estate planning. So, let me ask you this. Did you know your ancestral property in India could actually become relevant for UK inheritance tax planning? I know, this might sound completely shocking, but it is the new reality. If you've built a life in the UK over many years, your worldwide assets you probably thought were completely safe and entirely out of the British government's reach, are facing a brand new financial reality. Here is what we're going to cover today. First, we'll look at the end of domicile. Second, the long-term resident trap. Third, the IHT tail. Fourth, the impact on your ancestral property. And finally, number 5, the treaties and strategic planning you can use to protect your family's legacy. Section 1. The end of domicile. To really grasp where we're going with this, we first have to understand what we're leaving behind. For over 150 years, the UK relied on this highly subjective concept to figure out who paid inheritance tax, but that era officially ended on April 6, 2025. Under the old system, literally everything revolved around your domicile, which acted as the ultimate shield for global wealth. Now, your domicile wasn't necessarily where you lived day to day. It was the country you regarded as your permanent ultimate home. So, as long as you held on to your foreign passport, maintained your ties back home, and fully intended to eventually return to your home country, say India, your foreign assets were entirely safe from British death duties. You were considered non-domiciled. It's honestly a night and day difference when you compare the two. The legacy regime was subjective. It cared about your feelings, your intentions, and your roots. The modern regime? Well, it doesn't care about your intentions at all. Today, tax exposure is based strictly and mathematically on your physical tax residency history in the UK. Which brings us to Section 2, the long-term resident trap. Tax professionals are urgently sounding the alarm on this one, because this is the exact mechanism that suddenly pulls your global wealth into the UK tax net. Here's the kicker, the 10 out of 20 rule. If you've been a UK tax resident for at least 10 out of the preceding 20 tax years, you are now legally classified as a long-term resident, or LTR. The literal moment you hit that 10-year mark, your status automatically flips. Boom. Suddenly, your entire global estate is pulled directly into the UK tax net. There are no grace periods, and there are absolutely no exceptions for cultural alignment.
And what does falling into that net actually mean for your wallet? It means 40%. That is the staggering standard rate of UK inheritance tax. Your worldwide wealth, literally everything you own across the globe, above the standard £325,000 nil rate band, is suddenly exposed to a massive 40% tax charge.
Let's move to Section 3, beware the IHT tail. Now, you might be thinking, okay, if I hit 9 years, I'll just pack up and leave the UK. Problem solved, right? Well, not quite. Let me introduce you to a very dangerous complication known as the IHT tail.
Because even more surprising, leaving the UK doesn't always end the exposure immediately. A post-departure tail period may continue to apply. If you were classified as a long-term resident when you packed your bags and left the country, your non-UK assets actually remain exposed to UK taxes long after your departure. You simply cannot switch off your tax residency overnight to escape the taxman.
When you break down the numbers, it basically operates on a sliding scale so you can self-diagnose your exposure. If you lived in the UK for 10 to 13 years, your tail is 3 years. But it gets worse. Someone who lived in the UK for 20 years or more remains fully exposed to UK tax on their worldwide assets for an entire decade after moving away. So if you retire to Portugal or return to India after a 20-year career in London and you pass away 8 years later, the UK government is still taxing your global estate. Crazy, right? Section 4, impact on ancestral property. Let's dive into how these new rules specifically impact assets held overseas. We're going to use India as our prime example here, because this is exactly where families are getting caught entirely off guard. Under the new regime, worldwide assets can include so much more than you might think. We're talking about your family home in India, multi-generational agricultural land, commercial property, Indian investments like NRE or NRO bank deposits, even family business interests. All of these assets are treated as taxable. Imagine inheriting a property in Mumbai that has been in your family for generations, only to discover it creates a massive, unexpected cash liability for your heirs in the UK simply because of where you happen to live for a decade. And here is a massive, kind of hidden danger buried deep within the tax code. The UK offers certain reliefs, like agricultural property relief, which can shield UK farmland from inheritance tax. But here is the catch. No UK agricultural property relief is available for foreign agricultural land. So while an English farm might get a nice tax break, your family's agricultural land in Punjab will not. It is left entirely exposed to face that full 40% tax rate.
Finally, Section 5, Treaties and Strategic Planning. Hearing all of this can admittedly be terrifying, but I promise you, there are incredibly powerful, fully legal solutions available if you structure your affairs correctly ahead of time.
One of the absolute most fascinating tools we have is this: the 1956 UK-India Estate Duty Treaty. Yes, a treaty from literally 1956. Now, even though India abolished its own estate duty back in 1985, this historic treaty remains active and binding in UK domestic law. And remarkably, it can actually override the new domestic long-term resident rules for individuals who properly maintain their Indian domicile under common law. It's a real game changer.
So how do you actually build a strategic defense for your wealth? It's basically a three-step process. Step 1, review your residence history. You must actively track your physical residency to know exactly when you hit that 10-year LTR trigger. Step 2 is absolutely critical: separation of wills. You must use a separate Indian will for your Indian assets. If you use a single UK worldwide will, you accidentally trigger the UK's proper law rule, submitting your Indian assets to English succession law and destroying your treaty protection. And Step 3, domicile defense. You need to actively document your intention to return to India, retaining things like your Indian passport and social ties.
Just look at how correctly separating your estate planning literally alters your family's destiny. If you go the route of inactive compliance, where you do nothing, or you just use a basic high street UK will for everything, the result is your worldwide assets get taxed at 40%. But if you use proactive treaty planning, strategically invoking that 1956 treaty, and keeping your Indian assets governed by an Indian will, that exact same Indian estate passes to your children completely tax-free. You can literally save your family's legacy from a devastating million-pound tax bill just by having the right paperwork.
The key message here isn't to panic, it's to plan. Review your residence history, understand your estate, and seek coordinated UK-India advice well before succession planning becomes urgent. The rules have radically changed, for sure, but the power to protect your wealth is still entirely in your hands if you act proactively.
We've covered a lot of ground today, from the end of domicile to the incredible power of the 1956 treaty. So, take a moment to calculate your long-term residence status and ask yourself today, is your ancestral property truly secure? Don't let your family discover this rule too late. Are you prepared to protect your legacy? I really hope this explainer has given you the clarity you need to take that next step. Thanks for joining me.